moderator's prerogative. So we're going to talk now about common ground in validating forensic disciplines, and to moderate this panel is the other member of our inaugural class of research fellows, Sandra Mayson. Sandy comes to us from Yale and NYU Law School with a stint at the New Orleans Public Defenders and 2 federal clerkships. She's done an amazing job with us, and we're thrilled to have her here to moderate the panel on validating forensic disciplines, along with the august group that I will allow her to introduce. Take it away.
Wonderful. Thank you, John. So as John said, I'm Sandy. I have the honor to moderate this panel. My current work has focused on bail and pretrial detention, actually, not forensic science. So I will be learning along with you today, and I'm excited to do that. The title of the panel in your programs was Finding Common Ground in Validating Forensic Sciences. But we're going to take a little bit of a broader view, and we're going to try to identify points of consensus on practical next steps we can and should take to improve forensic sciences more broadly and ensure their appropriate use in criminal proceedings. For those of you like me who are relatively new to this field, just a little bit of background. Since Sherlock, right, the allure of using science to solve criminal cases has been powerful. And indeed, since the turn of the 20th century, when the analysis of latent fingerprints became widespread, forensic evidence has revolutionized the investigation and prosecution of crimes. More recently, some of you may be fans, CSI has enthralled viewers and set possibly unrealistic expectations about the power of forensic science evidence to help us identify, prosecute, and convict people who have committed terrible crimes. On the other hand, forensic evidence has also helped us to identify, prosecute, and convict some number of people who did not commit the crimes for which they were convicted. As John said earlier today, of the 2,000-some cases currently listed on the National Registry of Exonerations, faulty or misleading forensic science evidence played a role in 481. Just in the last couple years, a couple of high-profile events have called our collective attention to the frailties of forensic science evidence. 2 examples. In 2015, the FBI concluded a review of cases in which its experts had provided expert testimony relating to microscopic hair comparison analysis. And the FBI concluded that in 90% of those cases, its experts had testified to erroneous statements or with unwarranted confidence. Just Tuesday, John also mentioned earlier, Massachusetts prosecutors decided to drop 21,000 criminal cases in which the evidence had been undermined because of the actions of one rogue lab chemist, Annie Dukin, who had been faking lab test results. Right? So these events and others like them over the last decade have illuminated the limitations and the frailty, as I said before, of forensic science evidence and have prompted critique. So a couple of big milestone events. In 2009, the National Academy of Sciences published a seminal report called Strengthening Forensic Science in the United States, A Path Forward, which concluded that the forensic science system, encompassing both research and practice, has serious problems that can only be addressed by a national commitment to overhaul the current structure that supports the forensic science community in this country. One result of that report, and you all will correct me if I get any of this wrong, was in 2013, the National Institute of Standards and Technology, NIST, and the Department of Justice, DOJ, entered a Memorandum of Understanding, an MOU, to take a national leadership role in helping move forensic sciences forward. And my understanding is that led to the establishment of 2 entities, the National Commission on Forensic Science, and the OSAC structure, the Organization of Scientific Area Committees, which report to a new Forensic Science Standards Board. All good so far? All right, great. So these entities have been up and running, and These have been exciting developments you'll hear more about from the panelists. Then most recently, in 2016, the President's Council of Advisors on Science and Technology released a report, the PCAST Report, addressed to the question of what else is necessary from a scientific perspective to improve forensic sciences and ensure their appropriate use in criminal proceedings. And the PCAST report concluded that there still remain two big gaps. Number one, a need for clarity about scientific standards for the validity and reliability of forensic methods. And two, the need to evaluate specific forensic methods against those criteria for validity and reliability. Now, and then the PCAST report also evaluated 6 forensic methods against the criteria for validity and reliability that the PCAST authors proposed. They concluded that at least 3 of the methods they evaluated, and I believe it's bite mark analysis, firearms tool mark analysis, and the analysis of DNA mixed source samples, and shoe print, footprint, right, analysis, at least did not yet meet their criteria for foundational or basic scientific validity. So that critique also prompted critique. The FBI's published response to the PCAST report was mostly, in my view, critical, and the DOJ announced that it would not be accepting the recommendations of the PCAST report in practice. So we've arrived at something of a forensics crossroads. On the one hand, there's much greater awareness than ever before of the limitations of forensic evidence. On the other, there is considerable and well-founded resistance in some quarters to some of the most dramatic reforms and changes that have been proposed. The question for us today is, where do we go from here? Is there common ground on practical, achievable steps that we can and should take in the near term to improve forensic evidence and ensure its appropriate use in criminal proceedings? And to address that question, we are thrilled to welcome 3 incredible panelists with vast experience in this field. I'm just going to introduce them briefly. To my immediate right is Julia Leighton. Forgive me, please, if I say her name's wrong, just correct me. She is the former general counsel for the Public Defender Service of the District of Columbia, where she was also a founding member of the Public Defender Service's Forensic Practice Group. In 2014, she was appointed by the Attorney General to serve as a member of the National Commission on Forensic Science. Earlier in her career, Julia litigated criminal cases, both at the Public Defender Service and in the Environmental Crimes Division of the DOJ. To her right is Jonathan Wroblewski, who is currently the director of the Office of Policy and Legislation in the Criminal Division of the DOJ, where he leads a team of analysts and attorneys who develop, review, and evaluate national policy and legislation relating to crime, sentencing, and corrections. So he has a lot of free time, right? And in that free time, he also represents the Attorney General on the U.S. Sentencing Commission, the Federal Judicial Conference's Advisory Committee on the Criminal Rules, and the ABA's Criminal Justice Council. He also teaches at Harvard Law School and runs their Semester in Washington program. And earlier in his career, he served as an assistant public defender in Alameda County, a prosecutor in the DOJ's Civil Rights Division, as deputy general counsel and director of legislative affairs at the Sentencing Commission, that's the U.S. Sentencing Commission. And finally, in 2015 and 16, he led the DOJ's Office of Legal Policy, serving as the primary policy advisor to the Attorney General. And to my far right is Cary. You're going to have to help me, Cary.
Oien.
Cary Oien, who is a senior forensic scientist in the scientific analysis section of the FBI laboratory, in which capacity he supports the pattern-based forensic science disciplines. He began his career as a forensic examiner in the trace evidence unit of the FBI lab, and he has served as chief of the trace evidence unit, the firearms tool marks unit, and the scientific analysis section. We are honored that all 3 of you could be with us. We're going to start with short presentations from the panelists, followed by moderated discussion, and we'll try to keep ample time for audience Q&A at the end.
Good afternoon. So a little bit about me, and then I'm going to, as I understand it, I'm trying to set forth a little bit about the trial perspective on what's been happening, how we got here, what the history of our interaction with forensic science is on the trial level. As was mentioned, I spent 11 years trying cases, though a little of that time was actually in the appellate division. I did both criminal defense and I prosecuted environmental crimes. As a result, I dealt with medical examiners, forensic psychologists, forensic psychiatrists, firearms, fingerprinting, and then some cool stuff, or at least I thought it was cool at the time, fingerprinting pollutants so we could figure out what ships it came off of, or we thought we could figure out what ships it came off of. And during this time period, the challenges that I brought, or that my office brought, or that were brought from the other side when I was doing prosecution, were what we thought of as the softer sciences. It was things like child suggestibility, conclusions about the cause of injuries or the trajectory of bullets through bodies. And we didn't look at fingerprints, firearms. And I think that the reason for that is, frankly, that if we could have done math, we would have been doctors. We would have, if we had had a science background, we would have gone into engineering. We wouldn't have been lawyers. So I think that judges and lawyers are particularly ill-equipped to think about things from a truly scientific perspective. But we were pushed a little during the DNA wars. I came into that a little later because I was actually at DOJ doing environmental stuff when the true DNA wars were ongoing. But when I came back to the Public Defender Service in 2005, we founded a forensic practice group and started to get to work. And we started with DNA. And if you start with DNA, you have to learn something about science. You have to start learning about frequencies, you have to learn about population studies, you have to learn about theories of independence and what counts as proof of independence between loci, and if this makes you glaze over, don't worry. The point that I make about this is it finally forced us to learn something about science and scientific methodology, because this forensic tool had a very, very short lifespan from science to the forensic application. There were experts on all sides that were readily available to us because the Human Genome Project and what was going on in biology was very exciting, and there were a lot of people involved. When those sort of settled out, and this was usually sole source DNA, and I'm not talking about complex mixtures or even necessarily the statistics on mitochondrial DNA. But once those sort of settled out, I think the defense community, which is what I was part of at the time, so the only thing I can speak to, though I should say I'm not speaking for any institution, I'm giving my personal views. I think I was supposed to say that in the beginning. We started to look at the other disciplines, because now that we knew something about science, it was, well, what about these other disciplines? And I think that we started to try and call them into question, but we were really stuck with the power of precedent. And the power of precedent, as those of you who are practicing attorneys know, is it's overwhelming, especially at the trial level. No judge wants to be the first. How many of you have heard a judge say, well, if you're right, the Court of Appeals will deal with that. But this is the way we've always been doing it, and this is how I'm going to keep on doing it. And it didn't matter that precedent was often established pre-Frye or pre-Dauber, right? We'd been using fingerprints and tool marks and other trace pattern matching evidence for decades. Then the National Academy of Sciences report that you heard about came out, and we thought, oh, wow, this is a watershed moment. Not so much. It wasn't for courts. And for those of you that were involved in any litigation at that time, I'm sure you heard what I heard at least twice, which is, you can file that report with your pleadings, but don't expect me to read it. And part of it is that it wasn't very accessible to courts and judges, I think. Part of it was, again, we had precedent. And part of it was, frankly, that the government's attack on the report was effective. I'm not saying right, I'm just saying effective. They relied on precedent. I think they relied on essentially a scientifically illiterate bench and bar. We got some movement. People stopped using 100% certain. But, we moved to stuff like reasonable degree of ballistic certainty, which I think reasonable minds would think, well, that's no clearer than anything else you could say. What does that mean? But what did happen, I think, as a result of that report is it started a conversation. It started a conversation from forward-looking individuals in all of the components of the criminal justice system. Judges, lawyers, forensic scientists, and it started a conversation that just got some legs on it. And as a result, I think we ended up with the OSAC, the Commission, and the PCAST report. And I think that all three of those share some very important attributes to a greater or lesser extent. And that is that they're open, that they're public, that they involved a dialogue between stakeholders and the forensic science community, research scientists, and statisticians. Now, they're structured to do them in different ways, and I have some thoughts on which were more successful and which are less successful. But this was certainly different than anything that had happened before. I will tell you now that this administration decided to sunset the commission. I think that's a mistake. But I think that even with what I perceive, and I think we'll see what happens over the next few months. I don't think we're going to get answers now as to where the Department of Justice is going to go. And I'm going to be watching that with a great deal of personal interest. But even if there's a pullback, which I think is coming, I think this conversation will continue. And the reason I think it's going to continue is because I think scientists, research scientists in greater numbers are engaged. And I think there are a growing number of thought leaders in the forensic science community itself that are engaged in a science-based dialogue. But I think there's some very significant barriers that remain, and I'd like to touch on a couple of those. First, there is a large population within the forensic science community that has a very strongly held, what I would say is an anti-scientific belief that validity and reliability can be established through individual experience and the collective experience in the field and the history of use in courts. We've always done it, nobody showed us to be wrong. Well, that's backwards. That's not how science works. But what's important about this barrier is that it's strongly held personal belief by a lot of very good, hardworking, well-meaning people. And so what happens is that suggestions otherwise, that this isn't how you establish validity and reliability, are received as a personal affront, an attack on an individual's integrity, on their competence. And what science tells us, behavioral sciences tell us, is if you do that, you're going to get a real defensive unwillingness to listen, that change in that environment is very hard. I mean, I remember when we went to email in my office. Change is hard. It doesn't matter whether you're a forensic science community or the liberal public defender community. Change is really, really hard. The second, that's I think the first largest barrier. The second barrier, I think, is what an empirical approach to estimating the limits and uncertainty and error rates of these disciplines means. If we undertake this effort to do an empirical assessment of limitations, error rates, what does that mean about all the convictions that have already happened? I think that is the pink elephant in the room. What's going to happen to ongoing cases? What does even acknowledging that we need to do this empirical work mean as we move forward? And I think there's just, whether people acknowledge it or not, there is a damage control mindset that just has to be assessed and addressed. And I recall somebody that actually was one of the authors on the NAS report saying the following not long after the report was released. When he was arguing that this didn't mean everything had to stop, he said, you know, we're flying a plane here. I mean, we got to keep it going. We got to fix it. We got to keep it going, but we're flying a plane here. And I thought, if I was on a plane and the pilot came on and said there's some things wrong with the plane, I'd say, land it. Land it. I'll be late. But it is this mentality within the criminal justice system, and I think it's phrased in this way: if we don't keep moving forward, public safety is at risk. Bad things will happen to good people. Fear is invoked. The third barrier, I think, is that the legal institutions and our culture are very poorly suited to ferreting out validity and reliability. As I said earlier, the lawyers, the bench, we're not scientists. We don't have a scientific background. We don't have a mathematical background. We have a culture that's opposite to a culture of science, right? We're an adversarial system. For good reason, law enforcement is secret in many respects. It's not a culture of always being open and transparent about your data. Instead, it's a system in which people are always looking for an advantage, a way to win. That's what we're charged with. We're looking for a smoking gun that answers the case. And I think those make us particularly unsuited for this. The fourth barrier I see is, even if we solve the other three, even if the world happens the way I want it to happen, which is that we actually do the studies we need to do and start to collect the data and come up with accurate and reliable information about the validity and reliability of each discipline, how do we communicate what we find to jurors? I think that's a footnote that just isn't part of this discussion, but it's going to be very real. And it's going to creep in if we end up taking an incremental approach, which I suspect is what's going to happen, of how we're going to explain this to jurors. So with that, I'll turn it over.
Thank you very much. It's very, very nice to be here. I'm a repeat offender. This is the second time I've been here at the Quattrone Center, and it's a great joy. First, I want to just say I think we have a lot that we agree on, Julia. I think the conversation and the work will continue regardless of what we do at the Justice Department. I think everybody's roles are changing. We're not quite sure what that means. But I think the work will continue, and we all have to figure out exactly what our roles are going forward. The words to the, I also agree, change is hard, but I think change can happen. I believe that because I've seen it over the last year, over the last many years. So change can happen. It is hard. And then there's one thing I do want to talk about that I don't think is a footnote, and that's the words to the jurors. In fact, not only don't I think it's a footnote, I think it's actually the key element to all of this. And I'll talk about that in a second. One other thing I want to mention just in reaction to our first two speakers, and that is that words really matter. If you're trying to find common ground, the words really matter. So somebody in the first panel talked about the criminal justice system being broken. I was speaking to about 100 new assistant United States attorneys, and I asked them, how many of you think the criminal justice system is broken? And you might imagine, I got very few hands raised. And then I asked them right after that, how many of you think that there's room for improvement in the criminal justice system? And everybody raised their hand. Okay, so I'm not sure whether we want to keep using the word broken. Maybe you do, maybe you don't. But the words really matter. And defensiveness and behavioral economics and all of that, it's real. And I just recommend that we think very carefully about the words. So one other set of words that I want to take issue with, and that's the Justice Department rejected the PCAST recommendations. No, that's not right. The Justice Department supported 90% of the PCAST recommendations. The Justice Department objected and opposed one recommendation, and that was the recommendation by a group of scientists that said that until there is scientific validity as defined by PCAST, that evidence related to those disciplines that have not yet been validated should not be admitted. And we objected to that. And we objected to that again. That's why I think this words to jurors matters and is the key. Let me come back to all of that in just a second. Let me first say that I've been interested in this from the first days of being a lawyer. As mentioned, I started my career as a public defender in Alameda County, that's Oakland and Berkeley and that area, back in 1986. Anybody have any idea what the two most common types of cases that you would get as a public defender in municipal court in Oakland in 1986? DUI. One, DUI, correct? Pardon me? No. One hand-to-hand sale of 1 rock of crack cocaine. Okay, those were the two cases. And I remember getting those cases and getting the police reports and the discovery, which is at that time, was handing over a small package of papers. And they included forensic evidence, reports from something called a breathalyzer test or a blood test. And following up on the discussion from the first panel, there may have only been 1 hour of work on bail in law school in your criminal procedure class. Does anybody have any idea how much forensic science work is done in law school? Okay, again, I asked these assistant United States attorneys how many of them had ever had a class in forensic science. Nobody raised their hand. I had never had a class. I was asked to defend this person. I had no idea what this thing that said a breathalyzer test and it was 0.12. Or this report that said this rock was in fact cocaine. Very, very important that our law schools think about this. I was also focused on criminal justice from the first day I walked into law school. I went through the Stanford Law School criminal justice curriculum in about 2 semesters. I was ill prepared. And so I think that's one thing. And again, Julia is right. We are not, as lawyers, particularly well suited for this, but we need to understand it. It is very, very important. The last year of the Obama administration, I had the great pleasure of leading the Office of Legal Policy, which is the department-wide policy office. We not only did work on forensics, we did work on eyewitness identification, law enforcement encounters with the mentally ill, discovery. The common theme through almost all of that was preventing errors. And this particular area is so ripe for it. And remember what forensics are. Forensics range from somebody has to collect the evidence, somebody has to label the evidence, catalog the evidence, analyze the evidence, communicate that analysis to the litigants, and then ultimately communicate that to the jurors. All of those steps are done by human beings and are fraught with potential for errors. And each one of those steps need to be addressed. And I'm very proud of the work that we had done over the last year or so in conjunction with the National Commission on Forensic Science. And I just want to talk about a few of those accomplishments and then talk about a few of the challenges moving forward. So those accomplishments included accreditation. What does accreditation mean? It means that there are standards and best practices that we have to live up to. And in the Justice Department, all of our forensic labs have been accredited. Code of Professional Responsibility was recommended by the Commission. We adopted it with one small change. We adopted it. What does that mean? Again, standards for practices for those in the forensics field. Discovery policy. It was recommended, led by Judge Jed Rakoff in New York, but by the Commission, that there should be changes to the discovery practices In January of 2017, those changes were announced, and there is basically open file discovery for forensic information in the federal system. Eliminating the use of reasonable scientific certainty, that language, that was adopted. Quality assurance documents online, requiring root cause analysis, interoperability of latent fingerprints. There are steps after steps after steps that can be adopted where common ground can be found, and I'm telling you we found them. And that's not to say that there's no further work to do. There's a tremendous amount of further work to do, but I'm just here to tell you that common ground can be found and improvements can be made. Language is very, very important. Being able to talk to one another, to identify problems, identify solutions without finger pointing, all very, very important. Let me talk about just a couple more things. Do I have 2 or 3 more minutes? 2 minutes, okay. First of all, Attorney General Sessions' announcement. Okay. If you just read the Washington Post the day after his announcement about forensic science, you would assume that we have now put our heads in the sand at the Justice Department. We don't like science anymore. We disbanded this national commission, and science is gone from our vocabulary. That is not accurate, and you don't have to take my word for it. Go on the Justice Department website and actually read the press release. Okay? The National Commission on Forensic Science was scheduled to terminate long before President Trump was elected. What Attorney General Sessions said is that he's not sure exactly what steps need to happen going forward. And he said, I'm going to allow this to terminate. I'm going to explore the possibility of an Office of Forensic Science in the Justice Department, and then I'm going to ask the public through a Federal Register notice, which has been already placed, on how we can improve forensic science going forward. And I'm going to ask a subcommittee of my Violent Crime Task Force to review all of those suggestions and to come up with a plan, a strategy for where to move forward on forensic science. That's what actually happened. Don't take my word for it. Read the press release. It's on the internet, okay? You can find the Federal Register notice. And this is where the roles change, okay? You all have a role to play, and that's communicating to the Attorney General what you think should happen. And let me just talk about 2 projects which we began in the last administration, and now they're on hold, pending. They may continue, they may not continue. One is something called the Uniform Language on Testimony and Reports. And this is the key aspect. This is not, again, not a footnote. It's actually the center, I think, of a lot of the controversy. There are many disciplines that have not been validated, forensic disciplines that have not been validated. So, for example, shoe prints. I like shoe prints because I can understand it, okay? But remember, there is a disconnect between scientists and lawyers. Julia is absolutely right, and we have to understand why that exists, okay? Now, take an example. A friend of mine who lives in Northern California had her home burglarized. Someone broke in the window, came into the house, stepped on the couch as they were coming in, and left a shoe print. The police came, examined the shoe print, took measurements, took photographs. In court, I think every single one of us would agree that shoe print is relevant evidence. Okay? If somebody was caught just hours away, we know that that shoe print is relevant. If that person who is caught is wearing the same size shoe as the shoe print, if they're wearing a shoe that has the same design, the same measurements, if they happen to have a shoe that has a nail sticking out of the heel, and oh my God, on the print there is a little mark in the exact same place with the measurements from the side, we all know that that's relevant evidence. Okay, is it a match? I don't think that's the right word, okay? What is the right word? I don't know. But that's the project that we began in the uniform language of testimony and reports, trying to figure out what are the right words to use when you have a discipline that we don't have perfect information, we don't have perfect science, we have a lot of experience, we have a lot of studies, we have a lot to say, and this evidence is coming in. The scientists would say, the scientists have told us, we've been in front of them many times, and they would say, you can say it's consistent with or it's inconsistent with, and that's it. Okay. The problem is that a jury needs to make a determination beyond a reasonable doubt about whether this human being is the one who burgled that house. And they want more. They want to know more. Now, one possibility is we can just leave the shoe print to them, right, with no expert. I would suggest that's not the right answer, that we should come up with uniform language. The second thing, and then I'm going to stop, and it's the Forensic Science Discipline Review. This was a project that we began about 14, 15 months ago. It's a quality control project to identify where our analysts may be testifying beyond what this uniform language / the science permits. We know that there were problems with testimony related to microscopic hair. We don't know whether there were problems related to other disciplines, especially comparison disciplines. And so the idea is, why don't we do a quality control, a review of certain transcripts? That proposal is also pending. And again, if you all have anything to say on that, I strongly encourage you, respond to the Federal Register notice. Julia is right, it's going to be several months before we know what the Justice Department will do. And part of what will determine that is what you say, what the other forensic scientists say, what the other commissions on forensic science, what law enforcement says. So please participate. It's part of your new role, and those roles may continue to change. Sorry.
Thank you.
Drop the mic. Sorry. All right, I want to express my thanks to John Holloway and to Sandra for inviting me to be part of this discussion. I'm coming from a very different aspect, actually, from anything I've heard today. I'm probably one of the lone scientists, practicing scientists in the room. I'll start out by saying any opinions or points of view are expressed are mine, are not necessarily the official position of the FBI or the Department of Justice. One of those things I have to say. As Sandra said, I serve as a senior level scientist. Sandra asked me to give you a little sense of what the FBI laboratory is all about, and I'll do that as I'm going through some of my comments here. She also talked about some of the disciplines or the units that I've been in, but the FBI is one division within, the laboratory is one division within the FBI, and obviously the FBI is one component of the Department of Justice. In traditional forensic casework, we do work in around 15 or so different disciplines. I don't know if you call that a full service laboratory, but we do support a variety of different disciplines. In my position, I support a subset of those as a senior level scientist, and I support those within the scientific analysis section. And as Sandra said, it's the pattern-based. I'm not a big fan of that term because it's really not all-inclusive. I support really the trace evidence disciplines and then a few more also. What's also important, I'm going to come back to this a little bit, is I serve as the chairman of the Lab Division's Research Review Team, and I'll come back to that. That team is comprised of 5 other senior level scientists. So there's 6 of us within the division that serve on this review team. And we all have, I would say, our own portfolio of areas or disciplines that we support. We have one person in DNA, one in the chemistry and toxicology area, one in the explosives area, one in the chemical, biological, radiological, nuclear evidence area, and then we have a new addition. It's taken a while to get there, but we do have now a statistician within our ranks as one of our senior level scientists. Been working on that for a couple of years, but I think that's a hugely important addition to our complement of senior levels. From my standpoint, the goal of forensic science is for us to get the right answer, communicate that answer to the lay person, but also to continuously improve our ability to get higher quantity and higher quality information from that evidence. So it seems like a very big goal to have. We do a couple of different things within the laboratory to strive to meet those goals. First and foremost, we seek to implement a culture of scientific excellence and continuous improvement. The last talking about continuous improvement and the Sentinel events review going on at DOJ, we have similar events going on within the laboratory, and I'll touch on those in a little bit. But as far as the culture of scientific excellence, it's really centered on our research and the research that we're doing. You can kind of define the way and the reasons that we do research in the FBI, 3 different areas. 1, develop new capabilities. 2, improve our existing capabilities. And then 3, providing more support for our current and then our future capabilities. Okay, as I said, this process is managed by this research review team, of which I'm the chair. And we serve not to do the research, but to kind of shepherd the process. We are all senior members within the laboratory, and we are the process holders. So we're vetting the ideas, we're ensuring that the research idea has a stakeholder, so we have a unit that's going to implement this, and then prioritize it for funding and execution. We have probably 60 or so current research projects going on. Excuse me. And that's spread across our 9 research staff. Okay, that may be a shocking number to you. You think of the FBI doing all this research. We have a very, very small piece in the overall research mission. We have basically about 5% of our appropriated budget is geared towards research. So that's not very much money. We only have 9 people to do the vast majority of this research. So we have bandwidth issues. But in that research, we do strive to ensure that we are collaborating with all kinds of different entities. Certainly in academia, one of the abilities that we have is we bring in what are called visiting scientists. And these are students, basically, or postgrads that come in and really serve to augment our research workforce. So this program can be from 3 to 12 months, maybe up to 5 years, but it really helps increase our engagement with the students, and then when they go back out to their institutions, but also the institutions in which they're going to school. We also invest a lot of time collaborating with other government agencies. Gone are the days where we have huge research budgets and we can be embarking on a study and ATF is doing the same study and DEA is doing a similar. We can't operate in that environment. So we need to make sure we are collaborating across the community so we're not duplicating our efforts. We have a number of other government agencies that we routinely collaborate with. NIST, National Institute of Standards and Technology, is probably one of our bigger ones in a number of projects that I'll talk about in a little bit, but certainly NIJ, Department of Homeland Security, Department of Justice, Department of Energy, National Laboratories, and the list goes on and on. But we're looking for mutually beneficial technologies and methodologies that we can then implement into our casework. So for a research project to be approved, to be conducted within the laboratory division, it has to fit into one of our research portfolios. So we have basically different buckets that we will allow research to go on. And these are pretty big buckets. First bucket is called decision analysis and validation studies. We've heard a little bit about decision analysis. Equate decision analysis studies with black box studies. Next generation sequencing, developing new techniques and new technologies, and then emerging issues in forensic science. And then we have very specific research going on within a case working unit on a very specific, maybe a certain procedure. That's also a bucket, but really it's the four big buckets that we move forward on these major research projects that occupy most of our budget. The decision analysis and validation study, as I said, the black box type research was highlighted in the PCAST report as being very important work. I agree completely. The Leighton print study was highlighted in the PCAST report, and it was kind of held up as, I don't know if I want to say the gold standard, that's typically DNA in forensic science, but it's certainly something to model your studies after. That was a very robust study. It took a long time to do. Just a couple of data points. They had 170 different examiners participate in that test. There were 17,000 individual decisions that were reached in that test. But at the end, after all the data analysis, they're able to give some numbers on error rates, which I think are very important. So that wasn't just one study, that begat other studies. We call those the white box studies, just different terminology, but they looked at things like quantity, quality, value of the identification for exclusion, a whole suite of different things. So we think this is a very important area of research. This was initiated after the 2009 NAS report. 2 minutes, okay. And that's an area that we need to move into. So currently, we are in the midst of 3 additional validation or decision analysis studies. We have one in firearms and tool marks that is well on its way. We are in the sample development phase. Remember I said you had 17,000 individual decisions in the Leighton print study? Well, in order to conduct this firearms study, we need about 35,000 different test fires from the weapons. So it takes a while to generate that data. And we're coordinating with outside academic institution in order to move this technology or move this study forward. We also have 2 additional black box studies or decision analysis studies in shoe print and in question documents. Those are at the initiation phase. I want to touch on one I think is really important. A second bucket that we're doing research in is developing new techniques and technologies. We have very intensive efforts going on right now in the firearms realm, working very closely with NIST, National Institute of Standards and Technology, on using and utilizing 3-dimensional imaging technologies. Could be confocal microscopy. Bottom line for the non-scientist, what we're trying to do is move the firearms tool marks analysis from a subjective analysis where you're just looking at the test impression and the known bullet into a more objective. So we can use this technology to maybe give us numbers on do these two match, to use the word that I don't like either, match. But then language certainly is going to become important on how we communicate those results. I'm going to go over a little bit, I apologize. Kind of the second biggest area that we focus on is continuous improvement, and that's the accreditation, the quality system. Validation is certainly a huge part of that process, where we need to look at things like precision, accuracy, the robustness. But the results of these studies help inform us on the caveats or the limitations that we, as a forensic scientist, need to be aware of when we're discussing the results of these tests in court. For example, and this kind of ties into the alter discussion on what the approved standards are for what you can and cannot say for a given examination in court. Something like, okay, the research does not support that we can state a level of numerical certainty to support the identification of blood or semen through serological exams. Okay, I think that's incumbent upon us to let the court know, no, we cannot provide that type of thing. So that's kind of the end result of that, the research and the validation. It needs to get us to the point where it's telling us what we can and cannot say in court about a specific test and what we need to make sure the court is aware of. Seeing what I want to cut off here. Jonathan talked a little bit about the FSDRs. We certainly have that as a testimony review as an integral part of our quality system. And I guess I'll summarize with coming back to the topic of continuous improvement and preventing errors. I was very interested to hear the last speaker, Dr. Spivak, talking about root cause analysis, because that's a huge interest of mine specifically, something I've been working on very heavily for the last number of years. Root cause analysis is a requirement of our ISO accreditation, International Organization of Standardization. It's a requirement that when we identify an error or a problem, we have to do a root cause. I think over the years, we've not done a very good job of that. And what myself and another person in the laboratory are trying to work on doing is setting up a specific way that we conduct a root cause, or at least have a process for how you do that. And it has done some really good things. Now we're not dealing with the large issues that Dr. Spivak is talking about. We're talking about issues associated within a specific case, but it's been very hugely helpful to bring things back to the process and figure out what the issue was. But more importantly, the most important part of the root cause is not identifying the problem, but identifying the list of potential solutions. Because it's not about, okay, a problem occurred, you can't fix that one. We need to think about how do we mitigate our procedures to stop that from happening again. And I'll leave it with that.
Wonderful, thank you. Briefly, would any of you like to comment on anything anyone else has said? If not, we can move right into questions.
I'll take one thing. When I talked about, because I think we actually agree on juror communication, when I talked about making it a footnote, I was talking from the perspective of if, where we'll disagree is whether or not as of yet validated evidence ought to be introduced. But I was talking about a world where we actually conduct all these validation studies, and then we're talking about, are we using likelihood ratios, error rates, upper bound confidence levels, much more sophisticated statements about uncertainty. And that, I think, will be a whole nother conversation that happens after we reach that point. If we're doing something in the interim, and while I don't concede that we ought to be, I suspect that this conversation is more meaningful if we actually engage on what happens if there is an interim. Then yes, how we talk about it and how we instruct the jurors are going to be terribly important.
Well, let's try to establish which is the more likely path in the interim by I'm going to ask you all a true-false question. I'd like your opinion. On the PCAST report, a primary conclusion was that quantified or quantifiable error rates are necessary for basic scientific validity. True or false?
Yes, true.
I'm not sure that's the only definition of scientific validity, and we should take that as gospel and stop talking, okay? I don't think that's what science is about. Science is about continuously learning, and the PCAST report said that if you have 2 or 3 black box studies and you have an error rate, good to go. And if you don't, not good to go. I'm not sure. And the reason I'm so hesitant to say it, because PCAST, I met with President Obama's science advisor, who is the head of PCAST. I've met with a lot of those people. They know so much more about science than I will ever know in my life. They know more in one little pinky than I know in my whole. But talking to other scientists, I'm just not sure that is the only definition, and we should say, yeah, that's it. We can stop talking about it.
Cary?
Is that a yes or
Sure.
no, sir?
I think it's no.
I wrote down no, so I think it's no.
I guess I'll go back to a phrase that Jonathan used earlier. And if you talk to people at my lab, they will know I'm known for using this phrase. Words mean things. Okay, it's a slight permutation on yours. So when I look at the stance in the PCAST report, and I see things like the only way to establish, or you must do, or without these studies, the results are scientifically meaningless. Okay, I don't believe in absolutes like that. So I don't think that the only way to establish it is by doing this, and this. I mean, there's lots of different ways to get to the same endpoint in science.
And the common ground was, we should do more of these studies. So we're doing the black box studies. We agree with that. I think that there needs to be sufficient research going forward on the disciplines we know about, new disciplines. So that's again where I said, on terms of the PCAST recommendations, 90% agreement. But the problem at the end of the day, and this is where we disagreed, was if you don't have the black box studies, and we agree, we don't have them now for shoe prints. PCAST said, and I think Julia just said it, no testimony about that shoe print. Okay, that can't be the right answer, okay? Or it could, the answer could be, you can bring in somebody to show the photographs of the shoe print, but you can't say anything about it. We're just gonna leave it to the jurors with no expertise, no experience, no studies that have been done. That's the part that we disagreed with.
Let me make a suggestion and ask if we have consensus on this. Everyone agrees, there is common ground that empirical studies validating forensic methods in the sense of producing the data necessary to quantify error rates are a good thing that we should pursue. Is there agreement that forensic methods that have been evaluated according to those methods and for which we have adequately supported quantified error rates belong to some category of science that is distinct in a meaningful way and that we should have a term for, some common vocabulary for?
I'm not sure I understand the question entirely, but I think that's just science. I mean, I think what,
That's just-
you know, so it's like not science plus, I'm sorry, what it is or it isn't, right? So, I mean, what PCAST said is you can't make an empirical claim until it's not valid until it's been empirically tested, right? And so what I'm not hearing, and I suppose a question I have, is that's what science is. So what is it you guys want to introduce? And do you have a proposal of something you can say that satisfies, I'm sorry, I just took over the role. I have some questions.
No.
But-
No, that's good. This is good.
So what satisfies, is it the language of, look, I'm a plumber, I got 20 years of experience as a plumber, and when pipes burst like this, they usually burst like this for this reason. I don't know how often, I haven't really studied it, but that's opinion, testimony, because I used to be a tugboat driver, or because I used to be a plumber. I think there's a flip side problem we're going to have with that, which is the veneer that's been out there for a long time about what these things are and aren't. But how, that's just,
Yeah,
you
so
want
this-
to call it science.
No.
Or-
This is the no. I don't necessarily want to call it science, and this again gets to the rub of the year that I really worked on this for and the last part of the Obama administration was the conflict between the scientists and the lawyers. Okay, so yeah, the scientists say you can testify about that, just don't call it science. Okay, now. I have conflicts with some of my colleagues, and I think this is where you were right, that they want to call it science, and we can debate when they can call it science and when they can't call it science. But my point is that the legal standard for admissible evidence is not validated science. That's not what you'll find when you open up the Federal Rules of Evidence. Okay, it's relevance. Okay. That's the admissibility standard, is relevance. Now, are we fraught with problems when somebody comes in and says, I'm the plumber with 30 years experience, I've seen this a zillion times, I know for certain this was caused for this reason. Yes, that's the problem. And this is why the words, and the uniform language, especially for the disciplines that have not been adequately validated, is so important, because I think that we can all pretty much agree that shoe print evidence should be admitted, and that the measurements around that, which by the way some people call measurement, there's something called measurement science, but anyway, the measurements around it, the comparison, there's something there. And that the jurors are going to benefit from someone who knows more than I know to testify to something. Of course, what is that something? We can agree it's not a match, and there is an error rate associated with it. And this is why this project of coming up with that language is so important.
But the error rate that's associated with even what you've described, there's measurement uncertainty, correct me if I'm wrong here,
Yes.
but it can't be even that I measured it and it's 9 inches, because actually you don't know that. Because there's going to be a error built into your ability to measure a shoe print, especially if it's left on a variety of different surfaces, and you have to actually assess that. So I think that I heard in your answer a little bit about a demeaning of measurement science. Okay, then it wasn't there. All right, because it really is. It is there, and the problem, it seems to me, and this is, I think, what you all are struggling with, and goes back to the reason that I've argued with you in the past, that it's so important that you guys grapple with these ultras. Even if I'm not going to like the outcome, at least we can have a conversation about whether they end up, is that the shoe print, it may be that you have to be more particular about it in terms of saying, I can tell you that this is a Nike and here's why. I think, based on using a ruler, that it's a size 9, but it's in sand, so, and that's it. And I think you're going to have to be very careful about these little marks with the nails, and
Yes.
and to even opine that there's a connection between those, because that, again, I think is the point PCAST was making. If you want to draw a connection between the source and a piece of evidence, and you don't know its empirical value, it's meaningless. It is meaningless.
Let me intervene quickly and I'll ask Cary first to answer. I mean, why doesn't it map onto the difference between empirical and clinical sciences? Aren't there clinical sciences and we have clinical experts testify to their clinical expertise and practice? Would you be satisfied with a conceptual distinction between empirically validated forensic sciences and clinical forensic sciences?
I'm not sure what you're asking me, sorry.
Do you agree that with the PCAST criteria for empirical science? And is there room for another conception of science that we all acknowledge is just not empirical science?
I mean, sort of the medical example.
Yeah, exactly.
So the doctor who says, "Oh, I've made these measurements, now I have to come up with a diagnosis,
Right.
and I'm not sure if you have cancer or not. I don't know for sure, and not only that, I don't have an error rate.
Right.
Okay, but I'm going to give you my best advice. Now, I don't know if you call that clinical science. I don't know. Again, the words matter, and I don't know what to call it. All I'm saying is it's coming into evidence under the relevance standard, okay? And we have to be very careful because the words matter, because if you overstate it, the juror's going to get the wrong impression. So yes, and that's why I keep coming back to that those words are so critical and that we have to figure that out.
What I'm curious about for you, Cary, is whether you and the experts you work with would be receptive to that kind of a conceptual switch and that kind of language.
I mean, calling a distinction between the empirical and the non-empirically supported?
Yes.
I mean, I think our goal is to do these tests, to develop this information in all of these disciplines. So I think that's our end goal. And that's where I want us to be in the future.
And I think the problem with that is there's a solution to this problem. We don't have to reach to some sort of model that's not a good fit. From my perspective, the problem has been that courts have let it in, so there's been no pressure. There's no pressure. And I give a fair amount of credit to forward-thinking folks in the forensic science field that are dealing with even though the courts aren't, in my view. The courts haven't created the ultimate incentive, and if they did, it would happen really fast. Your budget wouldn't be 5%, your budget would be bigger. If it's excluded, it would be bigger. I'd bank the house on it. So I don't think we need to go chasing for a fit to not doing the work that everybody agrees needs. I shouldn't say everybody agrees. I think there's a world that would like to give you that group I talked about that feels that they've worked hard, they do good work, that they've always done it this way, nobody's shown that they've done it wrong, would love any kind of label that sounds like science and just to keep on doing things. But I think the thought leaders in the field don't want that. I think they want to get to more objective ways of doing the work and of being able to quantitatively evaluate the limitations.
Yeah, I think the leaders in the forensic community, first of all, they know we're moving forward. We cannot stop, okay? The world is not going to stop. There are going to be new discoveries, new technologies. This is going to be applied to the digital world. And so we're going to have to continue. The research is going to continue. This, by the way, needs to be institutionalized, okay? This isn't something like, okay, we can throw some money at it and in 2 or 3 years we're done. Okay, this is going to be just because of the nature of science and the nature of technological development. It needs to be institutionalized and continuous improvement, just as Cary said. And I think the leaders of the forensic community want to do it.
Yeah, and I think it's our responsibility as the forensic scientists for Those disciplines where we don't have this information right now on the error rates, if that's the standard that we're driving towards, I think that's one good one. I'm not saying that's the only research we should be doing. There's lots of other things. But it's also incumbent upon us to educate the court and the people involved in the process what our results mean. Now, one thing that forensic evidence tends to get packed all together into one big clump. Well, there are vast differences between many of the disciplines. If you take my background, the trace evidence disciplines, okay, that is what we call class level evidence. Okay, look at all the seats in the room. If I took a fiber sample from those seats, I probably couldn't tell them apart. So finding those fibers on somebody's clothing right now, okay, I couldn't put you in that seat, but I could say, well, the fibers are the same as these seats. They could have come from those seats, and then maybe somebody could reasonably infer that the person was in this room or there was a secondary transfer. So it's incumbent upon us, knowing at the outset that the best that I can do is class level evidence, I need to impart that information to the court so they know, no, this doesn't mean because I found this fiber, they were sitting in that seat. No, that's not the case. Now, our problems, and ideally, okay, talking about other research I would love for us to do, is to have databases of fibers. So we have some information on, well, how much of that is out there? Well, I would love to have that, and we're actually kind of looking to an organization that hasn't really been discussed yet, CSAFE. I don't know if I can remember the acronym. Center for
It's a
statistical group. I believe that's one of the areas that they're looking at is building these databases, but I can tell you, knowing textiles and knowing fibers, that's a huge lift. Partly because most fibers are now produced not in the United States, but even let's say they were all produced here, you have thousands of different dyes that can be added to the fibers before it's made into the textile. So just the thought of trying to build a population database makes my head spin. But that doesn't mean we can't do that, and we certainly look to the statistical community to help us, okay, if we were going to build this population database, how do we go about doing that? And I think those types of databases are going to help us in other areas of research in the future.
Why don't we open it up for audience questions, because we have a mere 12 minutes left.
Hi, so I have a question that may just reflect my lack of detailed familiarity with the PCAST report. But it strikes me that all of this conversation is about cases at the very margin, and that the predominant use of forensic evidence that affects defendants is front end, in applications for warrants, in proffers made about the strength of evidence at bond, in representations that are made in terms of encouraging, or one might argue coercing, plea bargains, and that the vast majority of that evidence is never reviewed or contested by defense lawyers. In fact, it may never be produced. Massachusetts is a really small example of that. If you waited until every forensic test was reviewed by a defense lawyer, in a lot of cases, you'd have maxed out on a crime you haven't been convicted of. So my question is this: what should science be doing about, and what should DOJ be doing about a vocabulary to be used in warrant applications, in gists, in complaints, and what criteria, if any, should be mandated for disclosure to the reviewing judge, so that even if the defense lawyer hasn't had an opportunity to conduct the examination, maybe it's not even available yet, the reviewing judge makes, and this goes back to our bond discussion, makes a meaningful assessment about the strength of the case with an educated perspective about the science, rather than some officer who says, it appears based on my training and experience that this is a match.
Right. Well, there's two parts of your question that I want to respond to. First of all is capacity. It's shocking to me when I was down in at the University of Texas last week talking on a forensic panel, an ABA forensic panel, and it was just shocking to me that in Harris County the delays that exist for the testing. So again, go back to my example of in Alameda County where someone is arrested for one rock. At arraignment, which is going to be within 2 days, you're going to have that piece of paper that says it was tested and we found it was going to be this. In Harris County, it might be 2 years later. And the shocking part about it is you find out 2 years later, of course, the person's pled guilty, been convicted, and then you get a report that says it wasn't cocaine at all. And what do you do about that? So the problem there is capacity, and it's a huge problem. The federal government's been and Attorney General Sessions, by the way, has been a huge supporter of the grant programs to ensure that there's greater capacity. You know, he already spoken about increasing that capacity. So that's number one. And then the other part of your question is until we either have those reports or even when we have those reports, when communicating to the court in any way, how should we do it? And again, that goes back to this uniform language. It will help define what can be said and what should be said. There will be an inclination, a human inclination, to say more. And by the way, the lawyers who don't know anything about this, both sides will push the forensic person, whoever that is, whether it's a police officer talking about gang terms that are used, or whether it's a lab analyst talking about what a particular substance is or is not. The lawyers will push them to say more than they really should be saying. And so getting some agreement, even or just getting something on paper on that uniform language, I think is going to be very helpful. And by the way, just to let you know, when we did that, we've done it twice at the Justice Department within the last year. We put a first draft out and we put it out for public comment. This isn't something that we're just coming up with ourselves. We came up with something, we put it out for public comment. I think it's fair to say there were sharp criticisms of them, but we took all that criticism to heart, and we came up with the ULTR 2.0. We put that out for public comment, and I think it's going to be an iterative process over a long period of time, but I think that's the way you get there.
So one of the things that I think was the unfinished work of the commission is standards for what should be in reports. And I must say that our inability to find common ground, and I think that it was probably still as a result of the fact that we were sunsetted before we could finish the hard work of putting these disparate voices together to find this common ground, is that the debate sort of tumbled on the issue of including in the report data or a summary of the data and observations, and including in the report what we termed figures of merits, which was to get at the issues of limitations and uncertainty. And I got to say, I found it very troubling, the pushback on that, because it really is back to the trust us when we tell you what it is, as opposed to show your work, which if you're going to be, even if you're not science, is still just sort of fundamental. And I think capacity is a huge part of it, but I also think a huge part of it is what's in the report. And what's in the report also protects the analyst, because the analyst can't go outside of that report very easily. If the limitations are in that report and I start talking about, well, and I think it's definitely a match, you've got something to cross-examine with, rather than, the PCAST report, which I think is terribly important. I actually do have some disagreements with it, but terribly important and not a useful tool in cross-examination, as all of us know that tried to use the NAS report. So I think, and it goes back to this, even the way you started to describe it, you were describing the situation where you said the orange may have come from, it's one of these seats, but I can't say which one. But the first thing that should have been out of your mouth after that sentence didn't happen, right? You got to it eventually, but it didn't happen, and it typically doesn't happen, which is, and I also can't tell you how common or not orange fabric like this is. It could be ubiquitous. And then we get into a question of relevance, right? It isn't all relevant. You know, if you can say it's a Nike size 9, that may not have a lot of relevance. You know, it becomes a ubiquitous shoe. And so, yes, it probably comes in because there's no prejudicial impact in that, because the layperson can understand that. It's going to get a little trickier with trace, where you don't have population databases and you don't put in that report, I can't tell you whether or not this fabric is ubiquitous.
Did you have something you wanted to say too, Cary, in response? Or?
I was going to go back to, I was going to agree with one of the first things that Julia said, that after the NAS report in 2009, we took a very hard look at our reports. Our reports, I mean, years ago, you had a line, here's a result, and there's a word. That's it. I disagree with that. So after the NAS report, we took a very hard look, and we turned now speaking just for the FBI laboratory, we turned our reports more into very similar to a scientific publication. So we have the materials and methods, we have the results, we have the discussion, we have the conclusion, we have the limitations. And I think that onus is on us to ensure that when we're putting out a report, we can't assume we're going to be there to defend that report or answer questions. So we need to put as much information as we can, most especially from my standpoint, the limitations of that technique. So the results or the weight of that does not get overrepresented. I think that's certainly incumbent upon us.
Let's try and take 2 more questions. Is that all right? All right.
Thank you. So I want to apologize very quickly because my question is a bit more philosophical than scientific, but it's directed to Jonathan primarily. And I keep thinking back to the example that keeps getting brought up about the shoe print and bringing it in, in terms of being relevant. And it seems to me that there's an apt analogy to be drawn with hearsay evidence, which, as we all know, is categorically excluded in all but very limited circumstances from trial because it's considered inherently unreliable. So there's obviously cases where hearsay evidence may be relevant to a case. Some statement might be made that, has some bearing on what the jurors may think or what the judge may think of the outcome, but we exclude all of this evidence. So my question for you, I guess, is, in terms of forensic evidence that is inherently unreliable, but you would admit it based on relevance anyway, do you think this is an apt analogy to hearsay? And if not, what do you think is the philosophical difference between that and forensic evidence?
So I don't think it's an apt analogy, and I'll tell you why. And I haven't thought about it very much, so I reserve the right to change my mind. Hearsay evidence is excluded because there is a preference for in-person testimony to allow for confrontation. The unreliability is not in the fact that it was done outside of the courtroom, that the statement was made outside the courtroom. The unreliability is in the statement to begin with, just a human communication of observation is also unreliable. That's evidence. It's unreliable. There's no error rate. There's no validation studies. It's unreliable, or it's at least of suspect reliability. And so we want that person to be in court so that it can be so that person can be cross-examined, and we can get at the level of unreliability. And of course, there are exceptions to the hearsay rule, and it's mostly when the person's unavailable. So when they die, when they've given a prior statement and it's been subject to cross-examination. I think the evidence, there's nothing unreliable about the impression on the couch of the shoe print. There's nothing unreliable about that. And there's nothing inherently unreliable of someone taking a picture of it and making measurements of that. And so bringing that into court, I don't think there's anything inherently suspect or unreliable about that. So I'm not sure the analogy works for me.
And our last question, Fred Quattrone.
I can appreciate the position that you took, Jonathan, that when you saw the PCAST report and it says this is the only way or this must be present, I get that completely. What I want to know is just very directly, if you think about some of the techniques that they called out as unreliable, let's just say bite mark analysis or microscopic hair analysis, is there any set of words that could be used in a new trial today that could justify the admission of that type of evidence? And consider that juries mostly believe the government when they put on a piece of technological evidence. They must be doing that for a reason. And so is there anything that could be said to cure, to justify, the admission of evidence that PCAST says is unreliable? Bite mark analysis, microscopic hair analysis specifically.
Yeah, remember, they didn't say those were unreliable. They said there was not sufficient validation. And we're now putting all into a bucket: bite marks, shoe prints, multi-source DNA. I can't remember the others, but there were 4 or 5, and firearms. Okay, those are not all equal, and so again, I think we're
just say bite mark.
Well, I don't know. To be honest with you, I don't know enough about bite marks to say one way or another. But I feel comfortable in saying that the standard that they're using for all 5 of those disciplines for admissibility, I continue to believe that's wrong. It may be right from the scientists to say, we don't consider it science. Okay, that's you, that's fine. But they went to the next step and they said, because we don't consider it science, because there's an insufficient number of black box studies and no known error rate, it cannot be admitted. And what I'm saying is, I think that as a rule, just as the general rule of thumb, not for as to bite marks, because I don't know enough about bite marks, but as a general rule of thumb, I think is the wrong rule.
And quick clarification. I mean, they said cannot be admitted as expert testimony. Do you take issue with that more limited admissibility criterion? Because I don't know that anyone disputes that it would be admissible as normal evidence so long as it meets relevance criteria.
Well, and prejudice versus prejudice.
Prejudice, right.
Yeah, so I'm not sure, okay, to be perfectly frank. And the reason is because what you're saying is, let's say they say it's relevant evidence, but it's not science. Let's take bite marks. Okay, so here's a picture of the bite mark on the victim, and here's a picture of the defendant's teeth and the impression that the defendant's teeth make. I'm not sure. I just want to leave that to the jury. Any more when I want to leave it to the jury, just here's the shoe print, here's the shoe. It's up to you. You're completely on your own because we're prevented from presenting any expert, even the plumber who has 20 years experience. We can't talk about that. We can't talk about anybody. I'm not sure.
But that, again.
And I have to catch a train.
We're gonna, I'm so sorry, Julia. We got to close out the panel because Jonathan has a train to catch. This conversation will continue right here.
Bring me back next year.
Yes,
Let's
yes.
have
At lunch and this evening.
finally got
Please
to
join
see-
me in thanking our panelists.
an